copy.
Thanks very much, and I would like to thank my hosts here and the Commission for supporting such a project, and also all of you, and also the translators, by the way, who have done a tremendously good job up to now, and in these conferences, in this workshop, is important to actually refer to them. I'll give some basic an outline of the legal framework for contributing data when coming from a public sector body. In the framework particularly of the Public Sector Information Directive. And I think this is important, is a very important framework, is a major cornerstone to opening up data and reusing data in the European Union. And I'll try to explain why it is so important to us. We always had an issue of trying to have a very clear and easy to follow regime for data reuse across the European Union. And this is important because reusers of data, as you very well know, they need to be able to draw from resources often coming from different member states. So they need to be multilingual, and they need to come from different jurisdictions. So for this reason, it is very important to have a legal framework which is both very clear and is very interoperable. And you need to be interoperable both at the level of the law, but also at the technical level. And in the last few years, we have done substantial work on ensuring that we are interoperable in the technical level. And what the PSI Directive does is ensuring that we have the level of legal interoperability we need in order to be able to share our data. And finally, we need to have simple redress mechanisms that allow for data reusers to be able to go and ask for the data, and if they get a negative answer, to be able to make sure they get a redress and be able to have access to those data at the end. So the final objective is to develop a single European market for innovative services and applications based on open data. And I think the directive to a great extent achieves that. The Public Sector Information Directive, the PSI Directive, that was passed in 2013, is basically the second Public Sector Information Directive we have in the Union. The first one was back in 2003. And this new directive amends the existing PSI directive, and it gives a major emphasis on open data, which means it's not just that we have a regime similar to the one we had in the past, but we have something in addition. It's not that you are just asking for data from public sector bodies. It's also that public sector bodies try to put data out there for the reusers to be able to have access to them. And open data appear in the recitals of the directive, which is an important step. We have a much clearer set of rules with regards to costs. The cost for actually giving data, which are not open, but people are allowed to reuse them, it has to be as close to the marginal cost as possible. So in a sense, this directive lowers the cost for users of data. It includes cultural institutions, museums, libraries, and archives, which is also quite important because such institutions have a lot of data which are very useful to us, especially when you're trying to build corpora. And finally, we have a clear regime for exclusive agreements in the context of the cultural institutions. We can discuss that during the Q&A session. And there is an emphasis on standard and machine-readable licenses. And I've done quite an extensive work on this issue. We used to have a myriad of different licenses. People wouldn't understand them. Now we are trying to have very limited set of licenses. So it's very easy both for the public sector body to make a choice and say, this is the license I want to use. Very simple, very easy. And also for the reuser to understand which are the terms under which they receive the information from the public sector body. So if we want to think how the public sector information rules work, it's very helpful to think along this stack of 4 different sets of rules. And different speakers before me made reference to some of them. So public sector information sits on the top of other legal regimes. And these other regimes ensure that when the right conditions are in place, you can make sure you can use the data. So public sector information tells you that public information that a public sector body holds is available for use, provided you have done a set of things. And let's try to see each one of these layers of the stack separately. The first one is the PSI rules themselves. PSI rules, the PSI regime says that whichever information does not contain the information that we're going to see later is allowed to be reused both for commercial and non-commercial purposes. So in a sentence, this is what the PSI Directive is about. The second thing is that, and this is something that those of you that work for public sector bodies know, is that sometimes we have more specific regimes. So for instance, when we have geodata, geographical information, we have a more specialized regime, which is defined by the INSPIRE Directive, and pretty much the INSPIRE Directive says similar things. The only difference is that it places a lot of emphasis on the metadata and their technical interoperability, as well as the sharing of this data between public sector bodies. You may also have in your national law some specific rules about statistical data. Most member states have. But this doesn't mean that such data should not be made available with the least possible restrictions to the end user. And that's what the PSI Directive is about. As I said before, the public sector information says that the public sector bodies should make information available both for commercial and non-commercial use. So it doesn't mean that you only have to give information without charging, or it doesn't mean that you only should give information to people that are not going to use it commercially. It is up to the public sector body, and it's up to the national policy you have to decide what are the ways in which you're going to make your data available. And we're going to see some examples later during the cases. The other thing is try to use as a simple licensing regime as possible. For instance, in many countries, we either have no licenses at all, which means that whatever information is published on a public website without any terms and conditions can be reused by the reuser, and that's a very recent example of that is Greece. Or we have countries which have a very limited set of licenses, which mean that you can use the information as long as you say where you got it from, and as long as this information actually doesn't belong to a third party. And that's the example of the United Kingdom, which has the open government license. So in all these cases, we have a very simple regime. And finally, the museums, libraries, and archives are within the context of the public sector information. And some speakers before me talked about this one. Here, the only qualifier we have, and it's a very important one, just because a library has books, it doesn't mean that these books are available to everyone for free. It needs to be books that are either in the public domain or we have obtained the relevant licenses. So it is important that we have the museums, the libraries and archives in the family of the public sector information, but we need to understand in more detail what it means. So let's go to the substratum, to the other layers below the PSI rules. The first one is the copyright rules. Here I have highlighted 2 key rules. The first one is that I check that the information that I have as a public sector body, that it is mine, that I own the rights on this information. If the information or this type of content belongs to a third party, for instance, it is a study which I have commissioned, but I haven't obtained the rights, I have to see the license under which this information has reached me. So I have to see how this information arrived here. The second basic rule is to check whether this information belongs to the public domain. So in several jurisdictions, information that is produced by public sector bodies by default is in the public domain. Or if you have a library that has a lot of old books, these old books, if they are, for instance, written more than 70 years after the death of the author, then these books belong to the public domain and can be freely reused. And this is very important because they constitute corpora which you could use for translation purposes. The other stack here of rules is the data protection rules. Here there is a very common misconception amongst public sector bodies which says, I have this data set, and this data set contains personal data, I cannot reuse it, I cannot make it available for reuse. This is not correct. And again, people here talked about this before. If the data set contains personal information, you just have to make sure either that you have a legal basis for processing it and giving it out, or you find a way to anonymize it. So, or you take the consent from the data subjects. So just because you have a data set that contains personal information, it doesn't mean you cannot provide it for use to a third party. And that's why it's very important to actually establish processes of anonymizing the data or making sure you have consent for the data you're processing. And I'm going to the final part, is that we have all sorts of material which we call excluded subject matter. These tend to be confidential information or trade secrets. These we find normally in ministries where they receive a lot of information by the private sector, or let's say ministries of commerce, or we can have this type of information in cases where we have ministries of finance, when we have trade secrets or confidential information. So here, a very simple rule is that if the information doesn't have a tag that says it is excluded subject matter, that it is confidential information, it's probably not. So it means you can reuse it. So again, this is an exception. So quite a lot of people, when we do these kinds of seminars, they ask us questions which tend to be very difficult cases. But these tend to be the 10% of the cases. So 10% of the cases are going to be difficult. You're going to have personal data, you're going to have confidential information, you're going to have third-party copyright. But 80%, you can just release the data. So try to focus on the 80% and leave the 20% for a question to the help desk of the ELRC, which is what we are here for. So if I want to summarize at this stage, I would say that the Public Sector Information Directive is like an aspirin, it's like paracetamol. It's like for this headache you have for the how I release data, and it really helps you to get rid of the headache. But it's always good to read the prescription and the instructions, and if you still cannot make sure that you know when to use it, just ask a doctor. So if you think of this metaphor, you can understand what the ELRC is for. So PSI is the pill, we try to be the doctors, and we try to give you some simple instructions as how to use it. A few more things about ELRC. Data are not to be reused as such. We mostly produce models out of the data and generate translations for new texts. Individual data points are used, not really extensive texts, which again is important to know for non-disclosing information that otherwise you shouldn't be disclosing. So let's try to take all this thing and put it in a set of steps. Very simple. What should I be doing in order to release my data? Basically, we just follow these stages, sorry, and you go from the red circle to the green circle, which is when I release the information. So the first thing, which is quite easy, is to see the document you have or the data set you have and check if you have any confidential information. And that's quite easy because normally confidential information is marked as such. So that's quite easy. It doesn't have a top secret thing on it, or it doesn't say confidential, it's not some weird statistical data. Then you've passed that stage. The second thing is a bit more tricky, is to actually see if there is personal data, and if there are personal data in the data set, then you check what you can do in order to get rid of this legal problem. And I talk about the legal problem than the personal data, because you could still release personal data if you have the consent of the data subject or you have a legal basis for it. If you have neither of them, you should make sure you anonymize the data. Third stage, you check, all right, this thing I have in front of me, this set of data or these documents or these pictures, are they really mine? And again, this is something that for some people is not very clear. Just because you are a public sector body and you have a set of reports on your desk or on your hard drive, they're not necessarily yours. Try to see who made them. If it's you that you have made them, then it's definitely yours. If you've made them through a subcontractor or a contractor, just try to see what are the documents through which you, actually the legal documents through which you receive the material. Then you know that you can do things with this, and you try to see how you're going to release it. And this is where the national public sector information rules tell you how to do so. In some countries, it would be just release it, just you don't need anything else. In some other countries, it tells you to, the rules tell you to choose between different licenses. So check what are your national licenses, choose one of them, make sure you release them. And just a point at the end, make sure you make it as simple as possible. It's not just simple for the recipients of the information, it's simple for you. If you have 10 different licenses, it's difficult to manage them. Try to stick with 1 or 2 open licenses, try to go for standard licenses like Creative Commons licenses, and then for the reuse licenses, the commercial licenses, use a framework like the UK licensing framework. So, and also the EU has produced a licensing framework. During the LAPSI project, we have these resources, and they're going to be available to you. So let me show you a couple of examples of how this thing is being done. I took 3 jurisdictions here. One is the, I think this was the first country transposing the directive, and it's interesting one is the Greek case of transparency project. It's called the Avia. The reason why I have this project here is, to be very honest, it was very difficult for the public sector bodies in Greece to actually choose licenses. So it required a capacity they didn't have. So the choice there was to actually make the material open by default. That was the cheapest and easiest and best option. That's a very interesting point. It says that all the data that are not going to be open, closed formally within a certain time period, they are open. And the French recently had a similar law, which gives us an indication of how you reduce complexity. Whenever they use a license, they use the Creative Commons Attribution license, which is a very simple license. It only says, use it, just tell us where you got it from. Second case is pretty much the same thing. It's a classic case of, again, it's Greece, is the classic case of the national publishing house, the national gazettes, where the different laws are out there. Here, they don't even use a license. They just have it out there. A third case, which I think is quite interesting, is the National Archives in the United Kingdom. The reason why I'm having this case here is because they are it's the very first country that has introduced open government licenses, even before the implementation of the Public Sector Information Directive. It's a very simple license. It resembles the Creative Commons Attribution license. It just says, again, use the material, just tell us where you got it from. Interesting thing here is that if you want to have a commercial license, they have a model license. So there is a template of a license which has some gaps. For instance, price, special terms, and duration. And each public sector body takes these templates, they fill it in, and they hand it to the commercial entity that wishes to have a one-to-one agreement. So a very simple system for how you handle the PSI. The legislation portal in the UK, the reason I have it here is because all legal data are there as open link data. So it's not just PDFs, and someone mentioned that before. That's a very good practice. They're true data. They're perfectly machine readable and processable. They're open, and they're also linked. Okay. Exclusive agreements, again I have the UK here because it's a country that has it for the longest possible time. I said that before, they have this template of the licenses. What is interesting, they have a report once per year. And in this report, they have the public sector bodies explaining why do I need to have an exclusive agreement? So the public sector body has to explain itself and say, I made an exclusive agreement with Microsoft or with Google or with Prodromos because it was very beneficial, because we used this money in order to develop other things, because we couldn't do otherwise. So, because that's what the commercial players want. And by the way, we had a session in another European project, the legal aspects of public sector information, about a year ago. And Google was very, we were discussing with a person from Google in the panel and saying, and Google was saying, we need exclusive agreements, or we need, even if they are not exclusive, we need separate agreements because we are very very interested in the service level of the agreement. So they know that these data are freely available. They know they could take them, but they want to pay to make sure that they will have it in 6 months' time or in 2 years' time. So the types of special agreements, to have a template ask you how to develop them is very useful. Then I have the case of DILA in France. Again, here is legal information and jurisprudence. Again, here they don't need a license. It's opened by law. You don't need a special set of rules in order to make them open. And then I have one case from ELRC. So there they have the corpus for Le Monde Diplomatique, the newspaper. That's a private entity. And what is interesting here is that we have 3 types of licenses. We have a license which is for research purposes only, a license which is for commercial use, and a license which is for evaluation, and then you can choose whether you're going to go for A or B. So I stop here with my case studies, and just giving you an overview of what we've seen. The legal regime we have right now in our hands is quite powerful. It allows interoperability between member states, and member states have started implementing it. They're using PSI legislation, the member states, for the past more than 10 years, so it's not something new. The legal tools are there, the technical tools are there, good practices exist. We want you to actually see these things we're presenting here today, see what kind of good practices you have. As I heard from the previous presentations, you have quite some good practices. And if you have some additional questions and more in-depth discussions you would like to have with us, it's not just a coffee break. We exist as a help desk as well. Thanks very much. Questions now? If you have a question, or even more than one question.